Donald Trump and his defense, they have been ordered to disclose one of the key defenses that could be used in the trial. Chutkan issuing 2 new orders that we're going to go through, specifically one talking about advice of counsel. Donald Trump has been saying that his lawyers told him to do certain things, and the government is saying, well, if that's true, then we should have access to those emails where your lawyers told you to do the thing. So if you're going to be relying on advice of counsel, you got to tell us about it so that we can get access to all of your attorney-client privilege documents. And the judge is saying that, yeah, Trump, you do have to tell them what your key defenses are or else. And this is going to continue onward in this courtroom because this judge is holding this case to a very strict deadline in March. We're also going to review another order about those deadlines, and we'll see what she schedules for us soon. But this is a quick update from the docket just to show you the latest filings. You can see here we have the pretrial notice of the advice of counsel defense motion. We've also got motions to compel deadlines being rescheduled for November and December, and various replies here on the docket itself. But the big ones were from Judge Chutkan, and she had 2 things that just came out recently, including this opinion and order talking about pretrial motions deadlines, and then the order about the advice of counsel defense. And so we'll start here today talking about this key defense that Trump has been talking a lot about in public on the media and elsewhere. But here you can see it's United States of America versus Donald Trump. It's a 3-pager coming from Judge Chutkan herself out of the January 6th courtroom, Washington, D.C. Circuit Court. And this is what she says about advice of counsel. She says, all right, Jack Smith and the deranged thugs over there at the DOJ, they filed a motion for formal pretrial notice of Trump's intent to rely on this defense. So, Your Honor, if he's going to be talking about this at trial, he needs to tell us so that we can go investigate and get discovery about it. Now, that motion from Jack Smith, it asks Chutkan to order that Donald Trump by December 18th, which is going to be here, like in the split, second, they want Trump to provide notice in court of his intent to assert the advice of counsel defense at trial, saying my lawyers told me to do it. And so the court from Chutkan is going to grant Jack Smith's motion and deny it in part. Now let's go through it. They say the advice of counsel defense requires that Trump, quote, introduce evidence that he relied in good faith on a lawyer's advice that his course of conduct was legal, right? That I can challenge the election, which I think is actually a good defense, right? Because I think that he has legal advice that told him that. The question is he going to use this advice because it might open him up to discovery that will involve communications between him and his team, right? So we have to ask ourselves, is it worth this defense? He made a full disclosure. So if he does rely on his attorneys and the lawyers say it was illegal, if he made full disclosure of all of those facts to his attorney before receiving the advice at issue. So you can't only give your lawyer half the story and then rely on their advice to do something. Like your lawyer has to be properly advised. So if Trump did those 2 things, I would say it's a pretty good defense, right? He's probably got lawyers, I think probably a lot of them, who told him that he was allowed to ask Mike Pence to do what he asked Mike Pence to do. He's allowed to do that. And we know that because they changed what Mike Pence in that role is supposed to do now. It's now purely ceremonial and it's not what it once was. So Trump, by invoking the defense, if he were to do this, the blame the lawyer defense, we can call it, the defendant waives attorney-client privilege. Now we have to ask ourselves, like, is that something he wants to do? And must therefore disclose to the government all communications or evidence that he intends on to rely on to establish the defense. So maybe not all communications, right? But only those that he wants to rely on. Now, Jack Smith is going to say, no, we need everything. We need all the emails all the time from everybody everywhere because they want to open that box. Like they want to crack that shell and get in there. And Trump will say, no, it's like 3 emails where, like this one. They say, and any otherwise privileged communication that he does not intend to use at trial, but are relevant to proving or undermining it. You see that? So that's the danger zone right there. Uh-oh. So then Jack Smith can say, everything's relevant. Every single email from Trump is relevant. And it may not be relevant to proving it, but we think it's relevant to undermining it. And we've got to see everything. And they're going to say, we gave Trump a ton of discovery, 12 million pages or whatever the number is. And so we should get everything too. And guess what? Chutkan is going to give it to him. So this is where Trump is going to have to probably eat this one and say, we're not going to take a defense. We're not going to use this defense because if he does, Jack Smith is just going to open the door. Oh, perfect. Thanks, Judge. And then the judge is going to say, yeah, give him everything. Just give him your laptop. Give it to him right now. Just give it to him because that's Judge Chutkan for you. So she says the federal rules of criminal procedure and the local criminal rules do not expressly require advance notice of this advice of counsel defense. Okay. There's no actual rule that requires this to be done. But because waiting until trial to invoke the defense and comply with the disclosure obligations it triggers could cause what she'll call disruption and delay delay, some district courts have concluded they nonetheless have the inherent authority to order the defense to provide advance notice if they intend to assert the defense. So just to be ultra clear on how badly this screws the defense, which is just how this always works, there is no rule that requires the defense to tell the government their defense, because that's insane. It'd be like running a play in a football game and just notifying the other team, hey, it's third down and we're going to pass, so you know, and it's going to 34, which is usually, I think, a running back number, but you get the point. So this is making Trump disclose this. This is our playbook. This is our defense, and there's no real requirement under the law to do it. But they have just inherent, you see this, inherent authority to order Trump to tell the other side what he's doing before he's going to do it anyways. Now, other district courts, however, have concluded that they lack that authority. So other districts have said, no, why would we make the defense disclose their defense to the government? So it's split. And which way do you think Chutkan's going to go? So in this case, the court need not decide whether it has the authority to order defendant to provide notice, because he, quote, agrees to provide notice to the prosecution of whether he intends to pursue a formal advice of counsel at the time jury instructions are due, which is currently January 15th. Oh, okay, so this is interesting. So defendant also proposes, however, that rather than requiring disclosure immediately after he provides notice to the court, he says the court should solicit briefing to determine a reasonable schedule for that disclosure. Okay, so I see what's happening here. We'll break this down. Depending on the scope of the defendant's requested jury instruction on the advice of counsel defense. But Chutkan says, but Trump cites no precedent for that procedure, and it runs contrary to the standard practice of requiring that disclosure accompany notice. So if you're going to notify him about the defense, disclosure also has to come, since that notice waives attorney-client privilege. All right, so they say, indeed, notice without disclosure would have little practical value and would inject undue delay into the pretrial prep. So just to zoom out on this, because there's a lot going on. Trial is scheduled for this thing in March. Okay, I think it's March 3rd, if I'm right, because Super Tuesday, I think, is March 4th. And so what Trump's defense is trying to do is they're trying to delay. Okay, they want to postpone this badly. And if they could postpone it even, 90 days, any justification is going to put it right into election season. And so any postponement is really essentially going to mean it has to come after the election. So Chutkan is not going to let that move. So what Trump's people were trying to do here, which is clever, but she's not going to let him do it, is they were going to say, look, we're not going to fight you on this advice of counsel stuff. We will notify you on January 15th. And then on January 15th, once we notify you, then we'll schedule a hearing. Okay, so they'll put a January 15th, we'll notify you. Then, Your Honor, what we'll want is probably a hearing on that, maybe I don't know, in 2 weeks or so. So let's say January 31st, we have a scheduling order, a hearing, whatever, we get some scheduling done. Then they say, we'll have a disclosure due, let's say, because this trial's coming up fast, so I have disclosure by 7, let's say, in February. And then there's going to be a disclosure fight right here, right? They'll fight over this disclosure. Oh, no, the government says that we should give them this, and we say no. And so the government says, well, we don't have the proper disclosure on 2/7. And so then we come back, and so you can see we're running out of time. There's 30 days here to fight over the discovery. But the point is, the defense knows that this fight is going to take longer than 30 days. So they're saying, we'll let you know on 1/15, and then we can start to process all of this discovery. But the problem the judge is saying is, no, we're not going to let you do any of that, okay? When you come on the 15th, you need to know all of this. You need to know, disclosure needs to be made on the 15th date. We're not going to notify and then come up with a schedule. So she says, and also, she's also being clever about this, because she says, you already admitted that I have the power to require advance notice, right? So they're acknowledging that this court has some inherent power. Now, they were doing that, I think, because they were, gambling on this, that she might schedule it, and then they could have a scheduling sequence that would take them into a need for a motion to continue the 3-3 trial. And now the judge is not going to let them do that. She picked out the point and says, you agree with me. I can require this, and so I am going to require it, but I'm going to require it on the 15th. She says, accordingly, Jack Smith's motion for a pretrial notice of intent to rely on the defense of advice of counsel is granted. So Jack Smith gets to know, in part, but it's denied in part. As he has already consented to do, and you might ask yourself if that's a mistake to do that, or if it's a mistake to just fight this all the way to the actual trial date, or if that was a better strategy. They say Trump shall file formal notice whether he is going to use advice of counsel defense by January 15th, 2024. If Trump does provide affirmative notice that he's going to be using this defense, Trump must also provide the required discovery to the government at that time, right? right? All of this needs to be there. So all communication that Trump intends to use to establish the defense and otherwise privileged communication that he doesn't even intend to use, but that might be used to prove or undermine the defense. And so the other way that this could go, let's think about this, right? If we game it out, on 115, they could come and they could show up with like 3 emails, okay? Here you go. Yep, we're invoking. Perfect. We invoke. We got 3 emails there for you guys. Jack Smith says, oh no, we need 4,000 emails from you. And then we fight over that, right? Now this battle happens here. And Chutkan, orders something to happen very rapidly, disclose all emails from this date, from these accounts. And then I think there's a lot of risk here to this, because this area, there's a lot of risk here because Chutkan's order, I think, to clear this up, like if Trump shows up with limited discovery and Jack Smith wants more, Chutkan is going to give them more. So there's a lot of risk there. I tend to believe that they're not going to invoke the advice of counsel defense, if I had to guess on it, but we'll see. Now, Chutkan has ordered it be done by January 15th. If they do invoke it, they got to turn over some communications. If they don't invoke it, then they'll proceed to trial on all of the other incredibly problematic issues that the government has in their case. But Chutkan issued another order. This one's talking about some other pre-trial deadlines. So while we're on this topic, let's see what else is being scheduled for us as we enter into trial time. So this is from Judge Chutkan, another opinion in order. She says, now Donald Trump is filing several motions. We've got a couple of these. One was motions to compel for subpoenas, right? Trump wants subpoenas in particular for a lot of the January 6th type of materials that suddenly went missing. So Trump now seeks to extend those deadlines. Specifically, Trump requests that motions for subpoenas be due on February 9th and that motions to compel be due on a rolling basis. Judge says Trump offers several arguments in support of this motion. First, Trump says that the government's discovery production is not well organized. Now, again, to talk about deadlines, remember, it's the same timeline. Trump is asking for continuances. Motion for extension of time. Motions, extension, extension, extension. They're looking for any reason to bump the March 3rd date. If they can bump it even, 90 days or whatever, they'll probably find another reason to bump it again. So the judge does not want to move it. So she's going to be denying, I think, a lot of this stuff. But let's see. As long as the trial date doesn't move, she can move some of these prior deadlines, but let's see. She says, the government says, discovery is not well organized, okay? We need more time. We're also citing the fact that emails do not contain their attachments and the replies. So the emails are all like individualized. He says, this is ridiculous. We can't find anything in here. Second, Trump's defense argues that the discovery is voluminous and it continues to be provided on a rolling basis, making it difficult, if not impossible, to raise motions before the current deadline. So what they say is like, yeah, we got a full wheelbarrow full of stuff yesterday. We started writing our motion. We're like, hey, a motion to object, a motion to dismiss, blah, blah. And we woke up this morning and there's a new wheelbarrow full of more documents here. And we're going to wake up tomorrow and there's going to be another wheelbarrow. So how can we properly put together our motions if we don't know what's even coming in? And third, defense says that allowing later subpoenas will be more efficient than seeking the same documents during trial. So Trump wants more postponements as a tactical matter, right? Defendant also repeats his view that additional time is needed to preserve his rights to due process and the effective assistance of counsel, because as we've talked about, the discovery in this case is 8 to 12 Washington monuments of copy paper if you printed them all out. The attorneys said it's like, a dozen War and Pieces or whatever the analogy was, basically an impossible amount of discovery for all the attorneys to read, and they all need to read it. So they say, Chutkan says, well, surprise, most of those arguments from Trump are unpersuasive. First, Jack Smith, my hero, points out that the sole organizational defect cited by the defense was actually a best practice. Rather than compiling the email materials themselves, the government provided those materials in a format that would easily allow the defense to compile them in their preferred manner. And they didn't respond to that point, so they must be wrong. Second, Chutkan says, I've already heard your complaints about the volume of the discovery materials multiple times in this case, and I've concluded that the schedule that this court set would be appropriate given, for the example, the early production of the organized discovery. And this was the highlighter girl situation that we had. Chutkan said there's like sticky notes all over this thing, okay? And some person named Molly at the DOJ has a highlighter and organized it alphabetically for you, like with tabs and everything, which nobody cares about other than Molly and Judge Chutkan. The quantity of materials that were duplicative or to which the defense had already had access, so they don't need to read it anyways or even look at it since it's in the government's, possession, and the defendant's resources. So Trump is rich. That's it. Trump is rich, so he can review these materials because he's got a bunch of money to spend on lawyers. So in the interest of justice, Judge Chutkan says, the court must weigh, as it has, any request for additional time to review those materials against the disadvantages of backloading the pretrial schedule. schedule. And so their request for a deadline that is extended into February illustrates the problems inherent with additional delay. And we've been saying this here, my friends, she is not going to move this trial unless she's ordered to move it. On that schedule, those motions would not be ripe until March 1st. 3 days before the trial is scheduled to begin, right? And this is why Trump is asking for this stuff. They've already gamed it out. So after which the court would have to rule, the subpoenas, if any, would have to issue, the materials would have to be produced, Trump would have to review them. All of this could take time and it could frustrate the rule of expediting the process. Now, that said, the judge will permit one more partial extension of the deadline of about a month. That will still allow those motions to be briefed and decided and any subpoenaed materials to be produced and reviewed before the scheduled trial, right? And so the judge is being smart about this too. She's not a dummy here. Like, she knows what she's doing. She built in enough time for a couple little extensions, but she's not going to move the end of trial date. This is how they do it in general, but she's really, gamed out this timeline. So she says, with respect to motions to compel, the court will permit a deadline extension of about 2 weeks. As Trump requests, this will permit the parties to further confer regarding any outstanding discovery requests and will allow him time to file motions with respect to any other unresolved disputes. Now, after that deadline, Trump may seek leave to file any additional motions, but if the motions are related to discovery produced by the government following that deadline, that will preserve the right to raise the motions with respect to discovery. So this is the schedule. If there's any problems, complain about it later. Accordingly, the request for extension of time is granted in part and denied in part, and it's ordered new deadlines. All motions to compel, which are going to be juicy, we are just gearing up, man. It's crazy. Motions to compel November 27th, oppositions December 11th, replies December 18th. We're going to be in trial like any day. Motions for Rule 17 subpoenas 12/13, 12/27, and any replies by January 3rd, and we will be gearing up for jury selection in February with trial in March. It's going to be here before you know it, my friends. So that is from Tanya Chutkan, the United States District Court judge. Trump's attorneys are trying to ask for continuances and extensions so that they can have a fair trial in this case, not one that is scheduled literally the day before Super Tuesday, and one that is going to take and bog Trump down for 6 to 8 weeks maybe in a trial. So Chutkan holding firm on the trial date. We'll see what Trump's defense says about this. Of course, they're going to be fighting hard, appealing gag order rulings and all sorts of things. And so we'll be here to continue to cover this, my friends. Thank you for subscribing. Thank you for liking this video and joining us, sharing it with a friend or family member, going to Robert Gouveia to sign up for our daily newsletter where you can get the show reports translated and delivered to your inbox every day. And we'll be looking forward to seeing you on the next one.